In this installment of Washington Legal Foundation's Legally Brief video series, Brendan Tavelli, an attorney in the Washington, D.C. office of the law firm Proskauer Rose, will discuss a recent settlement between the Federal Trade Commission and social networking company Twitter and what lessons the settlement provides to other businesses engaged in the online space. Brendan?
Thanks, Glenn, and welcome everybody to today's presentation. Today we're talking about Twitter, which you probably know is a service that allows you to broadcast short messages called tweets using email or text message. For football fans out there and folks from Cincinnati, you might also know it as the reason why Chad Ochocinco is $25,000 poorer these days, thanks to some ill-advised text message sent during an NFL preseason game, which violated the league's social media policy. Now, the Bengals wide receiver is no stranger to being in trouble, as many of you know, and now, thanks to a recent enforcement action concerning its privacy and security practices, neither is Twitter. Some of the lessons learned from the FTC's settlement with Twitter aren't new, but some of them are. Now, to begin with, the foundation of the FTC's enforcement action against Twitter is not new. Instead, it merely reinforces the FTC's position that has been taking over a number of years. With respect to privacy and data security claims, that boils down to be honest and be reasonable. Don't make claims in your privacy policy that you can't back up, and don't ignore information security. Twitter promised its users administrative, physical, and electronic measures to protect their information from unauthorized access. The FTC came knocking on Twitter's door because it failed to do a number of things that it should have done to live up to that promise, not because it didn't have perfect security, and not because it failed to do any one particular thing. In this sense, the Twitter settlement and others like it make clear that the FTC does not expect you to be on the cutting edge of information security. The FTC expects you to act in a way that is appropriate for your business and is consistent with your representations to the public. If you're not doing that, then you have a problem, and the FTC may have a problem with you. Now, while the foundation of the FTC's enforcement action is not new, the target of the Twitter action is new. To date, the FTC's enforcement actions have focused on the collection and disclosure of information that is generally not for public consumption. For example, the FTC has reached numerous settlements with retailers and other consumer-facing businesses whose lax security practices resulted in the inadvertent disclosure of personal information that was collected in connection with consumer transactions. The Twitter settlement is the first against a social network, a medium whose primary motivation is arguably disclosure, not keeping things private. The FTC's enforcement action against Twitter is also the first that did not involve so-called sensitive personal information, things like social security numbers and credit card payment information that might be useful to identity thieves when it's compromised. Those of you that are on Twitter know that beyond your name, a unique login, and an email address, you really don't need much else to get on Twitter. And outside of your Twittering activities, that's basically all that Twitter collects. That didn't matter to the FTC in this case. In addition to the limited amount of consumer information and non-public information contained in user accounts, the FTC focused on hackers' manipulation of administrative controls to view private tweets and open up the channels through which these user-generated content communications were disseminated. It did so because Twitter offered users the opportunity to designate certain tweets as non-public, and it promised to respect the user's choices in its privacy policy. Now, by failing to take reasonable steps to limit access to administrative accounts, Twitter committed a deceptive trade practice. This latter insight is really the most important takeaway from the Twitter settlement. Regardless of what you might previously have thought, the FTC is saying that neither the medium nor the type of information matter. If you made a promise concerning information security in your privacy policy and you're not living up to it, that's a problem, and the FTC will come find you. So, in sum, for all of you in the IT and legal community, be careful when you craft your privacy policy. Take the time to do it right, and revisit it often to make sure that it says what you want it to say, that it's consistent with your actual practices. It's very important, so do it right. Thanks for joining me today, and good luck.